The last story for today also comes from Ars Technica, and the title is In IT, Need Cash? Cybersecurity whistleblowers are earning big payouts. Whoa.
I have turned you in 14 times, Jerry. Not a single dollar has come my way.
So, this, by the way, was becoming big news as I was leaving my prior role. The U.S. government is starting to enforce what they call the False Claims Act. And that's where you're making an assertion that something is a certain way, and it's not really that way. And it's a variant of what we've seen, the CISO of SolarWinds, being charged with, where he's purported to have made statements. I don't have any idea where the case is on that, so I'm not going to make any definitive statements. But the allegation was that he was making statements publicly that didn't line up with the reality behind the curtain. And so the government is really looking for the public's help in identifying cases where that's happening. And one of the subsets of people who know most are insiders. And this was the joke I was alluding to earlier. What is like one of the people that they are quoting in here was a CIO, I think, of a company. Yeah, he was the former chief information officer for Penn State University's Applied Research Laboratory. And he turned them in and got $250,000. Now, I guess the concern, I have no idea. There's absolutely no context. And so I'm not going to talk about that, talk like more hypothetically. If you're part of the problem, if you're part of the reason that problem exists, I guess I'm assuming maybe that the government is doing some kind of assessment to determine that, like, you're not creating the problem and then trying to benefit from the problem you created. I don't know.
Yeah. Did you have decision-making authority over the area being investigated?
Right.
Yeah. It reminds me a bit of, remember when the Business Software Alliance was telling everybody to turn your company in for software piracy?
Yeah.
Back in the 80s and 90s. I don't
very,
know how well that
so
worked, but that was a similar thing. Like, if you turned your company in, get your bosses and we'll give you money. It was very much a, don't let your boss cheat hardworking people like they cheat you. Like, there's a whole bunch of class warfare kind of wrapped up in that too. And I have no idea how effective that was as a campaign, but I remember it was around for a long time. It may still be going on. I don't know.
Yeah, I think that BSA these days is largely a lobbying organization.
There's more money in that anyway.
I assume so. And Oracle's, I think they've patented the process of suing companies or customers for license violation. Or at least that's what it feels like.
It's just part of the customer process with Oracle now. You just expect it. In fact, you can look forward to it. And if you play it right, it can be fun. Like an audit. Yeah. Like an IRS audit. The only other thing I'll say on this is, certainly I don't in any way condone anybody breaking the law, and I don't have anything against folks turning their companies in for doing bad things. Lord knows I've seen it. The only thing I will say is, understand that right, wrong, or indifferent, if you get labeled as somebody who's turned your company in or sued your company, that might hurt your future prospects with other employers. They may be more hesitant to hire you. I'm not saying it's right. I'm saying it's a fact.
So therefore, you should make sure that the reward allows you to retire. Yeah.
Bingo.
There you go.
Make it big. Show me the money.
But, look, I guess there's also instances where there's more at stake. Like certainly if you're trying to report on like bad patch hygiene and you're doing it because you're frustrated, that's different than, let's say, a case where, that some healthcare organization is not properly protecting patient information or secrets to, a nuclear submarine or I don't know. Again, I don't know what the case behind this person's, I'm assuming Applied Research Laboratory has some level of secrecy around it. So I'm going to guess there was government relevance in there, that they were entrusted with certain secrets for the government.
Yeah, one
So
of the examples that is interesting to give is somebody by the name of James Glenn sued Cisco over a video surveillance product that had known security flaws and yet was sold to numerous government agencies. There you go. Cisco eventually paid 8.6 million, of which Glenn walked away with 1 million, more than 1 million. So, I mean, that's an interesting one where, kind of reading between the lines, somebody inside was saying, hey, this has got flaws. Cisco, in theory, according to this, appeared to say, yeah, we don't care. We're not going to fix the flaws, and shipped it anyway, which in this case was found to be against the False Claims Act. And Cisco got fined a bunch of money, and the person who blew the whistle got over 1 million.
mm-hmm. Now, my understanding, by the way, and I'm not an attorney, I don't play one on TV, but my understanding is that at least the current application of the False Claims Act is really as it pertains to an entity doing business with the U.S. government. Mm-hmm. So, like, I don't think that if your florist is hiding some dirty IT secrets that you're gonna be able to capitalize on that. I think it has to have some relevance to the U.S. government where that provider, that company has made assertions to the government about their security which are not actually true, and that's what the False Claims Act is intending to cover. Again, I'm not a lawyer. People be happy to hear if I'm, all the ways I'm wrong, but there you have it.
But this one's kind of slippery, right? This is the same thing we've always talked about is these sorts of things. I'm sure that there's a whole bunch of language in there of like, customary, due diligence, appropriate. How do you define all those things when it comes to security? What is a security flaw versus a mistake, right? And how is the program run, and what is the level of state of the art of due diligence? If something ran through a static code analysis, a dynamic code analysis, and a risk review, and a threat modeling, and a peer code review, and still had a big old authentication bypass that everybody missed, is that a mistake, or is that a lack of proper due diligence that should be punished?
Well,
in this case,
yeah,
they would have to know about it and not dealt with it, and then somebody turned them in, right? So it's not exactly perfect, but it's one of those, it always scares me about when we're dealing with an adversarial situation, and this is what lawyers and case law and judges are all for, but what is the threshold of, appropriate due diligence? Or could something get really convoluted to something very low level that really wasn't a threat and assessed to not be a threat and turned into, was misunderstood and turned out to be a threat, and the company acted with, appropriate, what they thought appropriate risk management, said, it's fine. And then and truly thought it was, and then turned out bad guys were more inventive and found some way to get around it they didn't know about. I don't know. I just think of when you're dealing with a bad actor who's trying to find ways around you and maliciously bypass you, it's always tough for me to decide what is the right level of due diligence in that case.
Yeah, in these instances, it doesn't actually require a bad actor, right? This is before it happens, and I know. So I think it was in the aftermath of the SolarWinds case, and I could be wrong on this, but President Biden shortly thereafter signed an executive order that required the government to come up with this attestation form, and it was around secure software development. And I think there's certainly other applications of the False Claims Act, but I'm going to focus on this one because I think it's relevant to your question. That attestation requirement, and it was banging around in the government like what you exactly had to attest to for a long time, but it wasn't like you had to attest to that your software had like no vulnerabilities. You had to attest that you have a software development, secure software development process that you consistently apply, and that process has certain attributes about it. And, things like you don't release software that has known, let's say, higher critical severity vulnerabilities. Like, that's an objective thing, and it doesn't require somebody to say, or it doesn't require that to get hacked, right? It's like a statement of fact. Somebody consumes your piece of software and says, well, gosh, it's really interesting. You said that your software follows this process, which requires it to not have any higher or critical vulnerabilities when it's released. Yet, the software was released last week and it has a critical vulnerability that's 2 years old. How those two things can't coexist in the same timeline. And I think that's what they're trying to go after. And I suspect behind the curtain, it's some variation of, like, we tell the market that our software is secure, and yet I know that we're releasing products that have critical vulnerabilities, but they can't see it because it's compiled code or it's a service offering and they can't see behind the curtain or what have you.
Yeah, that's fair. I think I was probably going down the wrong.
No. I just trying to. It's a good discussion, and I don't even know if I'm on the right path.
Yeah.
This is, and by the way, it's probably all about to change. So
that's true. New administration.
So it's all about to change. A lot of this is being enforced by, like, the Federal Trade Commission and the Department of Justice and whatnot, and the Securities and Exchange Commission, in terms of kind of tangential requirements. I would imagine we're gonna see a ton of change. And so all the crap that we've been talking about for the last couple of years about consternating over, like, breach disclosure laws and misrepresenting security, I suspect a lot of that's about to change.
Yeah, certainly. I'm not talking about the value or the political benefit or detriment, or I'm not taking a stand here, but another one that I think is vastly going to impact us was the Chevron doctrine being struck down by the Supreme Court, which gave a lot of rulemaking authority to these federal agencies that had power of law. And in essence, the Supreme Court said, no, you don't have that rulemaking authority. That's Congress who has that rulemaking authority. Those regulations and rules didn't just get wiped out of existence, but I think they could be challenged now under that lack of Chevron doctrine, if that is the appropriate term. Again, not a lawyer, not a Supreme Court expert.
It is.
And some of these could very well be found to, hey, no, you've got to go back to Congress and get Congress to pass the law before they can be forced. So it could get very interesting. And again, not stating any sort of political stance on it, just the raw reality is that probably will cause a lot of change in the next couple of years, regardless of the administration, because that doctrine was struck down.